The laws in Britain and its colonies, the Americas, were very, very different. This was something that was clarified in the Somerset case, where Lord Mansfield made the famous judgment that James Somerset, who had been a slave in America, was free while he was in England. However, should he return to a colony where slavery was the law, he would again become a slave. This is actually still true today in the world. People who are brought as slaves from places where there is still slavery, such in various countries in Africa, are free while in England, but should they return home, may again become enslaved. The Somerset case in 1772 was a landmark, not because, as many people thought, it freed slaves in Britain, but because it confirmed that there were no laws relating to slavery in Britain, and therefore black people brought from the colonies where slavery was legal were free here. The problem was really that England had never thought about or formulated any rules for people who were bringing their slaves from the colonies where slavery was legal to England where no laws existed. The French had actually sorted this out. They had thought this through. They had rules in place whereby people who brought their slaves from the French colonies could keep them as slaves under certain conditions and for a certain period of time while they were actually in France. But the British had never actually thought this one through. The English colonies in the Caribbean and in America had promulgated laws related to slavery, but as Mansfield points out, English law had never done this. It would only be the passing of acts that could create slavery in this country. Interestingly, when he died, his will recorded that his great-niece, Dido Elizabeth Belle, who was mixed race, he confirmed that she was free. It did not say that he freed her, it confirmed her freedom. Now this is an odd thing, and lots of people have puzzled about it. Why should he need to say this in his will? This was because at the time, many eminent thinkers were suggesting that introducing slavery into Britain for the poor, not necessarily for the black, but for poor people, was a good idea. So I think Mansfield was just being ultra cautious about making it clear that Dido Elizabeth Belle was free. From Tudor times onwards, it was the responsibility of the parish to look after the poor, the unemployed, those too sick to work. And various laws were sort of promulgated, formulated to decide who had responsibility for looking after those who fell on hard times. In 1662, an act was passed which defined who had what was called settlement in a parish, the right to be supported by that parish should they fall on hard times. Now the primary way of gaining this, there were other ways, was through being born in a parish. This is why, very carefully in parish registers, the clerks will record that someone who is baptised was black or was born overseas. This made it quite clear that the parish had therefore had no legal obligation to look after them. There were other ways, of course, of gaining settlement. You could gain settlement through working in a parish for a year and being paid wages. Now, many servants, both black and white, weren't paid, so this was one of the problems of deciding who was entitled to settlement. The other ways that you could gain settlement in a parish were through serving a full apprenticeship of 7 years, or through renting or owning property worth more than a certain amount. This meant that people like Ignatius Sancho, who lived in Westminster, had a shop there. He had property worth more than 40 shillings, and therefore he had the vote. He is also not recorded as black in the records that relate to his marriage, the births of his children, even to his burial. Because he had settlement, his colour and his origin had become irrelevant. Although there was some doubt at least until 1772, about the status of black people brought from the colonies to England as servants, then there was no doubt at all about their status under the criminal law. We find from the records of the Old Bailey, all the proceedings were published, accounts of the trials, transcripts, all sorts of things were published. And we find from that black people appeared in all roles at the Old Bailey. Sometimes they were prosecuting cases against white people who had wronged them. Sometimes they were defendants because they were thieves or they had been involved in some crime. And sometimes they were called as witnesses because something interesting had happened. Now, this wouldn't necessarily have been possible in the colonies, where black people were not allowed to bring cases against white. But what we do see in the Old Bailey trials and in the accounts of people going about their daily lives, what they were doing when a crime happened, how very much black people were integrated into the life of the capital. There are perhaps 100,000 cases appearing at the Old Bailey, and in my period, I can't remember how many cases there were, 10,000 odd, but there's only about 200 black people max, which is extraordinary, a tiny, tiny proportion of those who appeared. So they were, and I also did the statistics on this, women were exceptionally law-abiding. There's hardly any black women. I mean, Anne Dark comes up all the time, but there are very, very few others.